SJC-11191, Commonwealth v. Lawrence Bynum Harris.
Thank you.
All right, let's proceed. Yes.
May it please the Court, Elizabeth Caddick for Lawrence Bynum Harris. Also, if I may, Justices, could I have 2 minutes for rebuttal?
Of course.
Thank you. The Massachusetts rules and due process require reciprocity by the Commonwealth when a defendant, pursuant to Rule 14, tenders his evaluating psychiatrist or psychologist's report in anticipation of raising a mental state defense, either insanity or, in this case, a so-called diminished capacity defense. That didn't happen in this case, and so there was both a Rule 14 violation and a due process violation. In this case, about 2 years before the trial, the Commonwealth filed a motion asking the court to order the defense to give to the Commonwealth both Dr. Carroll's evaluation on his competency to stand trial and Dr. DiCataldo's evaluation on the diminished capacity defense evaluation. The court ordered that the defendant hand these 2 reports over to the Commonwealth, and the defendant did so.
Or there was any, had the Commonwealth asked to have a forensic person appointed?
At the same time as the Commonwealth filed the motions for this information, the Commonwealth also filed permission to have its own competency
Competency or criminal responsibility?
Excuse me, I'm sorry, criminal responsibility evaluator. And the court granted all those motions at the same time.
So when you said the court ordered that Dr. Carroll's and Dr. Cataldo's evaluations be turned over to the Commonwealth?
Yes.
Not to the independent expert?
No.
To the Commonwealth itself? I mean, to the prosecutor?
Yes. Wow. And so that's why the prosecutor had a copy of Dr. Carroll's competency evaluation.
And was that to determine competency? Was that at the competency hearing?
Yes.
No, it was a motion hearing.
There wasn't a competency hearing because he was not declared incompetent. So this was perhaps about a year after the competency evaluation was performed, but after the defense had told the Commonwealth that it was going to raise this diminished capacity defense, that the Commonwealth then filed motions for these evaluations.
Not to exchange reports, but...
No.
So I'm assuming, I haven't looked at, was there a discussion at the hearing about the fact that Rule 14 wasn't being followed?
No. No, and the lawyer at the actual trial was not the lawyer representing Mr. Bynum Harris at these proceedings.
Wait, I'm sorry, you're referring to the report that was handed over was not your expert's report.
Yes, one of them was.
Yes.
The report of your expert?
Dr. DiCataldo. That is what was
both reports, both the competency and the criminal responsibility done by the defendant's expert.
Right.
But, well, Dr. Carroll wasn't the defendant's expert.
No, Dr. Carroll was the independent competency to proceed evaluator.
Right.
Right after the defendant's arrest.
Was he an employee of the Commonwealth?
Yes.
Yes.
Yes, at Bridgewater State Hospital.
Okay.
Yes.
So he's an employee of the Commonwealth who did this competency evaluation for the court.
Pursuant to a court order, right. Exactly.
And I'm confused. Why wouldn't that evaluation be turned over in the ordinary course to the Commonwealth?
Well, my understanding is because there was not a competency hearing, so it was sort of a dead issue. So there was no reason for it to be turned over. It was just part of his medical records.
The report was also turned over to Dr. Cataldo as well.
Yes.
So it was turned over to him. He had access to it and could review what had occurred during the time period in which he was at Bridgewater.
Right, and there were medical records that were the defendant's medical records.
So presumably, in terms of Dr. Carroll's report, if all had gone more directly, I mean, I'm just sort of picking up on what you said, assuming it happened this way, but if the independent evaluator had been appointed and the independent expert would have been entitled to the records of this, probably of the Bridgewater records, right? So Dr. Cataldo would have gotten it, whether or not it, I mean, at the time it was turned over to the Commonwealth, but I mean, I don't mean Dr. Cataldo. If the Commonwealth had had an independent expert, that expert would have been able to see it in any event, probably because it would have been included in the medical records of.
I don't know if that's the case, because when the cover letter with the competency evaluation, and from experience working in the trial court, it goes in a sealed envelope to the court.
Well, so how did Dr. DiCataldo get it?
The defense attorney had it. I don't know if there's somewhere in the district court docket there was a request that was granted for the defense to have a copy of it. I don't know. I mean, the defense can have a copy of it if the judge who ordered the competency evaluation ordered it. But the main issue is that Rule 14. Following this event, Rule 14 was not followed, although it appeared as if the Commonwealth was going to follow Rule 14, in that it did file a motion which was granted to have an independent, or to have its own therapist, a psychologist, psychiatrist evaluate Bynum Harris. That was granted, no further action was taken. And as the rule requires, even the rule in effect at the time of this trial, which was before the rules that were revised after Schlick-Broder, that there be a report by the Commonwealth's expert submitted, and the report has to include certain things, including what the evaluator bases his or her opinion on for this either insanity or diminished capacity evaluation. That didn't happen here. So not only was it a Rule 14 violation.
But you got Dr. Cataldo had Dr. Carroll's report.
Yes, but the report was first of all, the report was only for what his competency at that time was to proceed in his.
Also was an examination of his mental health, and unfortunately I left it in my office, but at the end of it, there's a whole section, I don't find him mentally ill.
What he said is, at this time...
Which is very close in time to the offense.
Right. At this time, I don't see that he's suffering from a major mental disorder that affects his ability to, assist or understand what's going on in the world. So so he's talking about a major mental illness. He's not suicidal. He was asked to determine what his ability was to participate.
And whether he needed mental health care at the time. Right,
because he had been making suicidal threats. So they wanted to know whether he needed to continue.
But when Dr. Carroll testified, did he go beyond the report that he had prepared?
No, but that's not the issue. The issue is one that the Commonwealth just didn't go by the whole reciprocity procedure. There was really no notice.
Does the Commonwealth have to? I mean, what if it decides it doesn't want to have an independent, doesn't need an independent or a court-ordered examination?
It doesn't have to have a court-ordered examination, but what it can't do is wait until a week before the final pretrial conference, say we're going to call the competency evaluator who got a waiver from Bynum Harris that only reached the competency hearing judge. The waiver was specific that Bynum Harris waived his Fifth Amendment right, but only for the purposes of Dr. Carroll testifying before or submitting a report to the judge who was going to hold a competency hearing.
Now, you're basing that on the report that speaks to the warnings of the limits of confidentiality? Is there anything else
Yes,
beyond that?
at the trial, the defense attorney asked Dr. Carroll, in fact, was Bynum Harris's waiver of his Fifth Amendment right only for the purposes of the competency hearing, and Dr. Carroll answered yes.
But then you said
Now-
it got stricken?
Yes.
What was the basis of striking it?
It's the judge said that it was irrelevant to the issue of, that it was irrelevant to the issue of whether Dr. Carroll was going to speak to whether Bynum Harris had a mental disease or defect. But we have on the record that Dr. Carroll specifically answered that, yes, his waiver was only for the competency hearing. And so what we have is a violation of his Fifth Amendment right. We also
Is below that this was the violation of his Fifth Amendment right?
it certainly the defense attorney raised the issue that the waiver a couple of times, both at the final pretrial hearing and right before at trial.
Fifth Amendment waiver that we're talking about here?
It's one of the sub-arguments that, and also the Fifth Amendment waiver goes into the third sub-argument, which has to do with
But according to the report, he said, I informed him, meaning the defendant, he did not have to meet with me, although I had to prepare a report to the court whether or not he met with me. So he didn't say you were compelled to speak with me.
No, he didn't say he was compelled, but the court order compelled him to speak with him. And so...
It did, or did the court order...
Well, the court...
A competency hearing, this seems to say, I have to do a report on competency. You don't have to speak with me. But I've got to do a report either way.
And what I believe he further said in that report is that I will reveal to the competency judge anything you say to me.
I informed him I would prepare a report that would be submitted to the Brockton District Court, that I might be required to provide oral testimony in court regarding these issues, and I think in fairness you can say the issue was going to be competency,
Yes.
because that was the purpose of the report.
Right, and he confirmed that at that.
Okay, so your view is that that constitutes a compulsion to speak to him limited to the issue of competency?
Right. And, well, Blaisdell says that a court-ordered competency, a court-ordered psychiatric evaluation is a form of compelled testimony. And also the U.S. Supreme Court in Estelle v. Smith and confirms that when it's a court-ordered competency evaluation, it's compelled testimony and Fifth and Sixth Amendment rights come into play. And the trial attorney did state that his waiver was only for the competency hearing, and stated that the actual information that Dr. Carroll obtained was only for competency. And that there has to be reciprocity. So he raised all of these issues, due process, Fifth Amendment, but also the Rule 14 violation. And so what we have is Mr. Bynum Harris and his lawyer thinking that he's only going to meet with Dr. Carroll and give statements. We know that Dr. Carroll's testimony was based on statements that Bynum Harris made to him, so the Fifth Amendment comes into play there, that both Bynum Harris and the attorney thought that those statements were only going to be used at a competency hearing if there was the need for a competency hearing. In fact, what happened is years later, it was learned that he had been made, the dupe of his own prosecution by his words now being used against him, or the fruits of his words. It may not be that Dr. Carroll quoted him, but that's not what's important. It's that his statements were used against him by Dr. Carroll. And so what we have is an unfair advantage. We have a violation of the reciprocity requirements, analogizing to the the rule of alibi witnesses when it was deemed that until the Commonwealth had a reciprocal obligation under the alibi rules, a defendant didn't have to give information about his alibi witnesses because that would be a violation of due process.
I don't really understand the unfairness of this. I mean, let's assume the Commonwealth had gone forward and say, okay, we'd like to have Dr. Carroll appointed, and Dr. Carroll said, okay, well, I've got my report here, and Dr. Cataldo has it, and now I come and testify. What would have happened differently?
Because it's still the statements that Bynum Harris made to him back when he didn't know they were going to be used against him. There's absolutely no problem with using Rule 14 as it's written, which is once the defendant raises his mental state as a defense, the Commonwealth can then get an expert to evaluate the defendant and get his statements then after he knows that there's a full waiver of all of the confidentiality, that it can be used against him at any stage in his criminal proceeding, and once he has the advice of his counsel of what to say.
But I thought this report was used by Dr. Cataldo in preparation for his opinion.
No, it was not. No.
The Commonwealth argues that it was part of the basis of his opinion.
It was not. He did not rely on it. The Commonwealth cited to the Seabrook case where the expert for the defense specifically said multiple times that he relied on the Commonwealth's expert's report in order to render his opinion, and that his opinion was based on that. That is not at all what happened here. What came out was that the statements that Bynum Harris's grandmother made to Dr. Carroll, Dr. DiCataldo used, in addition to using the statement she made to him personally, more closer to trial, but also that the prosecutor confirmed with Dr. DiCataldo that the basis of his diagnosis of Bynum Harris was based on DiCataldo's forensic tests and the MMPI and the other psych exams and his evaluation of Bynum Harris in 2008. And DiCataldo confirmed yes. So the basis of DiCataldo's diagnosis was of his interview and testing of Bynum Harris himself. He said nowhere in the record that it was based on what was included in Dr. Carroll's report. So this totally distinguishes Seabrook. Also, it's very unclear from looking at the reports what in Dr. Carroll's report was actually something Dr. Carroll was writing or whether he was quoting from medical records, because he does quote from some of the other, particularly the licensed social worker, and this isn't clear. And one of the reasons it's not clear is because those evaluations weren't part of the record. But there are times when, for a long period of time in his report, Dr. Carroll is quoting from the social worker. And so there are times when it appears as if Dr. DiCataldo is referring to Dr. Carroll's report, but it could actually be the medical records themselves by the social worker. But what we do have on the record is that he did not base his opinion on Dr. Carroll's report.
He testified to that? Is that what you're saying? It's
yes.
on the record?
Yeah. Well, I mean, did he specifically say, I never relied on it? No, what we have is he only relied on his evaluation in 2008, and that the basis, and that the only thing that the defense attorney was trying to get from DiCataldo about the psych report by Dr. Carroll was what the statements of the grandmother were, because it was a sidebar about it, about what he was trying to get out of that report.
All right, counsel, your time is up. Thank you.
Good afternoon, Gail McKenna, Assistant District Attorney for the Commonwealth. This is the Commonwealth's rebuttal case that we're talking about here. In this case, we have testimony from Dr. DiCataldo, who testified first, that he considered Dr. Carroll's report in the Bridgewater records in formulating his opinion here. He testified to that effect both on direct and in cross-examination. No matter what the status of the case, in rebuttal, the Commonwealth would have been entitled to call Dr. Carroll. Otherwise, what's left in the jury box is the inference that what happened or what Dr. Carroll believed was that his opinion was the same as Dr. DiCataldo.
What specifically did he say with regard to Dr. Carroll's testimony? That he had relied on it, that he had read it, that it was among the documents that he had reviewed?
That it was among the documents that he had reviewed. So implicitly, what's left is that this is part of what formulates his opinion, and that it's a positive part of what formulates his opinion.
But did he also say that I formed my opinion by I base my opinion on my interview of him and also the statements of the grandmother?
The statements of the grandmother, I believe, was part of a sidebar.
Okay.
A sidebar because he wanted to, defense counsel wanted to elicit from Dr. DiCataldo some of the hearsay underlying what the grandmother had said about him.
Isn't it always true, though, that in a case in which mental capacity is at issue, whether it's lack of criminal responsibility or something else,
right?
That are not always the case, but it is generally the case that the Commonwealth's expert on that topic comes in on redirect. After the defense expert has testified.
Well, it is usually the case, but not necessarily the case, because as the court is well aware, a defendant's mental capacity can be raised in the case in chief by...
I do understand that, but
Right.
but it's not... But generally, it is in rebuttal that the Commonwealth's expert testifies, at least in my experience.
And in my experience as well, Your Honor. But certainly, at the point when there's been testimony that this is something that's been relied on, we also have a report...
Reviewed, if I heard you correctly.
Well,
Reviewed, yes.
And we also have a report from Dr. DiCataldo where he verbatim recites from Dr. Carroll's report. So
Was that in evidence, by the way?
the report, no.
Okay.
The report was not in evidence.
Is it
but-
your view that if that had not come in, that you would not have been able to call as a rebuttal witness Dr. Carroll?
No, of course we would have been able to call Dr. Carroll as a rebuttal witness.
Okay, so what is the significance of the fact that Dr. Cataldo had read and that among the documents that Dr. Cataldo read was Dr. Carroll's report?
Well, it's something that we...
Why is that play into whether or not you can offer Dr. Carroll in rebuttal?
Well, it's something that we cross-examined him on and tested him on as far as what he considered as part of what he came up with his report. I'm talking about the state of the case, where this was offered in rebuttal to a witness who listed this as something that he relied on in what he considered in coming up with his opinion about a borderline personality disorder. Certainly, we should be able to offer a witness that examined an individual at a point in time close to the subject incident who has a differing opinion, and that opinion being that this individual suffered with no mental illness.
What do you say about your sister's argument that the agreement to speak with Dr. Carroll was limited to the use of that for the purpose of the competency report?
Well, I don't think that plays out in either the report or in the order of the district court judge that sent the defendant there.
And do we have that order? Is that part of this record?
It's not, Your Honor.
We don't know what the order says.
I think it's referenced in Dr. Carroll's report, but the defendant was sent there at the request of defense counsel and on the order of the district court for two reasons. He was sent there for a competency examination, and he was sent there on a quote-unquote safety examination based on the
Suicide
potential.
risk?
Thank you, the potential of a suicide. So he's sent there for two separate reasons. And that testimony did come out at trial that Dr. Carroll testified in cross-examination that he examined him for two separate reasons, not just for competency.
Neither of which was mental capacity at the time of the event.
But that doesn't prevent any professional who's an expert
Well, I guess
from
the
coming
problem
up.
I'm having with that, though, is, yes, that might but what do you do about all these very specific procedures in Rule 14?
Well, Rule 14 goes to how do we, the Commonwealth, get to try our case? And in rebuttal, if we don't need, an expert, why are we compelled to have an examination done when there's already been an examination done? I mean, we get to try our case in the way that's, having multiple examinations for no apparent purpose just doesn't really make sense.
Can I just
Rule
ask
4
you?
Sure.
Just in terms of the order of things, I think I heard defense counsel say that the court ordered the defendant to turn over Dr. DiCataldo's report about 2 years before trial. Wouldn't that be the point? Maybe I'm wrong, but I thought that it was turned over directly to the Commonwealth. That seems to be at odds with what the rule says.
Right.
And also, wouldn't it be the case that ordinarily, it would be turned over to the Commonwealth's expert, who's also basically doing, and this would be after a time when the Commonwealth would have asked to have the defendant examined by one of its own experts.
It was
and so it's all
simultaneous.
transparent what's going on, that there are two experts who are, using each other's reports, but the Commonwealth would not actually see that report unless and until, trial, ordinarily. So this is a significant departure from the way Rule 14 ordinarily works, including the surprise factor that Dr. Carroll's report, who had never really been part of this picture of, he'll get a copy of Dr. DiCataldo's report, and I think, there's this departure may have affected the transparency of the process.
I don't think that the court should be at all surprised that normally, or many times what happens in these cases is that where there is a truly viable mental health defense counsel is anxious to get all of those reports into the hands of the Commonwealth as soon as possible.
Notwithstanding what Rule 14 says.
Notwithstanding the rules.
Well-
And that is what happens in many, many cases.
How does that square with Schleich-Brodeur?
Well, Your Honor, at that point, there's no motions before the court, and people are voluntarily turning discovery over to each other to come to a just result.
But this was an order, wasn't it?
Well,
Didn't the judge order the defendant to give these things to the Commonwealth?
Let me step back. All of that was included in the appendix to my brief. None of this is raised as issues in the appeal. The orders are in the appendix to my brief. From what I can gather, because it's not part of the record, defense counsel wanted to raise a mental health portion defense as part of his voluntariness argument in the motion to suppress. He never did. So I think that's where that arose. Redacted copies were turned over to the Commonwealth. It doesn't appear that there was an objection. There's no record of that hearing. I don't know what. The record is barren on that. We do know that at the same time the Commonwealth did the Rule 14 motion. It was also allowed. All this is happening at the same time. But the only time that the discovery orders are going back and forth and Rule 14 is coming into play is when it looks like there's a contest that's heading on its way to trial. But many, many times we receive all of these reports without any court involvement because that's the way things are going. Our experts get them, the other experts get them, and it's a pretty transparent process.
So you're saying that as far as the record is concerned, assuming there was an order that Dr. Cataldo's report and Dr. Carroll's report were turned over to the Commonwealth, there was no objection to that in any event?
None that I'm aware of, Your Honor. If defense counsel was unhappy, there would have been a 211-3. I know this defense attorney, he would have gone to the wall if he had thought that there was a problem.
So as far as you know, these were not turned over pursuant to the Rule 14 regimen?
Correct.
Okay.
These were simply turned over pursuant to an order.
Now, is it your position that if the Commonwealth were to offer in rebuttal a psychologist or psychiatrist who had not interviewed the defendant pursuant to Rule 14, that you would have no obligation to provide in discovery the substance of that evaluation?
I think that we would. However, I mean, we're in a tough position in any rebuttal case. We don't necessarily know everything that a defendant is going to present. A defendant's case is not transparent to us for obvious reasons. Something that can come up in rebuttal, say we didn't know about Dr. Carroll. Suddenly we're calling Dr. Carroll on the phone and we're saying, come in here. The jury needs to hear from you because the jury now has the impression that you believe that this individual has a mental disease or disorder. At that point, defense counsel might have had that report, but we've only gotten it just before Dr. DiCataldo was testified. So what if we had to turn over at that point? We don't have anything.
Yeah,
but yet
that wasn't this case. I mean,
It wasn't, Your Honor.
In your pretrial discovery order, you identified Dr. Carroll as your witness.
Yes, we did, but I thought you were asking me a hypothetical question.
Well, no, but I mean, but it's just, I guess the principle which you articulate is that if we don't get an order from the court compelling the defendant to speak to an expert pursuant to Rule 14,
right,
then there is no obligation that we have under Rule 14 to provide notice as to what the substance will be of our rebuttal witness.
Not at all. In fact, we supplied all the information about Dr. Carroll. It's in my appendix. It was in the pretrial conference report, which the defendant had 26 days before these two experts got on the stand.
Okay, so now, but if it was, you gave the competency report here, but if there had not been a competency report and he had been some independent psychiatrist who you had retained and said, we're not going to have you interview him, just we're going to have you review the records and opine from that, is it your view that you'd have no obligation to?
We would turn that over under Brady. I mean, there's absolutely...
It's not Brady. It may not be exculpatory.
We would turn that over. I mean, we're not in the business of playing games. We would turn that over.
So you agree with the principle that when there is to be expert testimony in rebuttal, the defendant is entitled to know the substance and detail of what that testimony will be before he or she cross-examines your expert?
Unless for the very first time we're hearing about it on rebuttal, which happens. I mean, I'm sorry, in the defendant's direct case,
right,
which happens.
But you would have had to have notice of a mental health or diminished capacity defense.
But we wouldn't necessarily know what that witness is going to say. Or if that witness for the very first time brings up something that we've never heard of before, or a record of a particular hospitalization that we've never heard of before, that he suddenly is saying was crucial to his underlying diagnosis. We may never have heard of that before.
I understand that.
Which
and
changes...
So you've got to call a witness you never expected to call. That's not
right.
the case, of course. But
correct. And that's why I thought, Judge Gantz, that you were talking about a hypothetical here. So on the circumstances of what happened before the court, this is a witness that the defendant knew about from the beginning, that we gave notice of in our pretrial conference report that he would be called, that the opinion was fully well known to defense counsel, that as far as any privileges or any rights were concerned, he was fully protected by the law governing privilege here, and by the case law as well.
What do you mean by that?
Say again?
So what do you mean by that, he was fully protected?
The privileges here, including the statutory privileges, protect him from the use of any incriminatory material. I think it's 233-23B. And it also protects him from having to give over anything unless, of course, he's made a waiver, which is the Seabrooks case, and also the most recent Supreme Court case on this issue, Kansas versus Cheever, which is cited in my brief.
That's federal law, right?
No, the big Supreme Court, not
well. I mean, it's
Supreme Court.
It's our rules and our own Constitution may not be in accord with the Cheever case.
Right, but my sister did cite the Estelle versus Smith case as dispositive here, and I think that the later case, which explains that case, Kansas versus Cheever, which says that a court order is no obstacle to calling a witness in a rebuttal case, is important for this court.
But could I just ask you,
Sure.
I'm looking at the pretrial conference report. You say you named Dr. Carroll as a witness. I'm just trying, where in this record is that?
That's in my record appendix.
I thought that's what I'm looking at. I thought. I'm sure it's there. I'm just, which one is it?
Can I
Oh, I
assure-
see, I get it. It's going to
Yeah.
be it's a second joint pretrial. I'm looking at a pretrial conference report, but it's later.
Yes.
I see. Yes.
And as I said, by the time both witnesses testified, it was 26 days later. And I will add that defense counsel's strategic objective was to completely keep Dr. Carroll off the stand. He never asked for a continuance. He didn't ask for another report, which he could have asked to. And in the discretion of the court, it would have been up to the court to do either one. But the complete exclusion of the witness was not warranted here. He had this doctor's report from the get-go.
Now, your sister says that the rule should be that when somebody says, I will speak to a psychologist for the purpose of preparing a competency report, that whatever is said or the evaluation that arises from it may be used only for the competency report and not with respect to a determination of guilt.
Well, you know, that's troubling, Your Honor, because we very, very rarely in the law have complete disqualifications for certain types of witnesses. And in this case in particular, where no issues are raised that would rise to the level of a complete disqualification, it shouldn't be considered. I think what we do in the Commonwealth, at least, is that we want the jury to hear from any witness that can possibly shed light on the subject. And in a case like this, where we have an opinion close in time to the subject from an expert who can be cross-examined, we want him to come forward and say, no mental illness. And that's all that he said.
But you've got Fifth Amendment creeping in there. I mean,
What
it's
Fifth Amendment?
Well,
I mean, no statements were elicited at all here,
that's
Your
not
Honor.
the issue, though. If the opinion is based on the conversation with the defendant, whether the Dr. Carroll testifies to the exact statement seems to me not the real question. It's whether the opinion is based on compelled testimony.
Well, Your Honor, he did receive a Lamb warning, and there's no evidence at this trial that this doctor relied on any statement whatsoever in coming up with his opinion. I mean, we don't have any testimony about that.
He had to have.
He could have based it entirely on observations. He could have based it entirely on looking at other.
How can you make a decision on competency based on observations? Because somebody's on the ceiling? I mean,
Well, his counsel was, the defendant's counsel was with him during the competency examinations. And as this court said in Commonwealth versus Singh, the current ability to understand proceedings and to participate in the defense doesn't mean that you have to ask a single question about the underlying substantive crime.
No, I'm not saying
Not
it
a
does,
thing.
but you have to base it on things that are being said.
But that doesn't implicate the Fifth Amendment. You're not being interrogated. You're not being asked about the subject crime. The Fifth Amendment simply isn't that broad. You're being asked two things. Do you understand the proceedings, and can you participate in a defense? That's all, and those aren't Fifth Amendment issues. Those aren't incriminating issues. Just because you have a mental health defense doesn't mean that you've raised Fifth Amendment issues. I want to thank you all for your kind attention today, unless there's any other questions, and also thank you all for your kindness on Friday.
Thank you.
I'd ask that the conviction be affirmed.
Rebuttal?
Just to quickly go over the procedures involved in the defense being ordered by the court to turn over the competency evaluation. On R6 of the record appendix, page 6, the docket entries show the Commonwealth's motion and the court's order. On record appendix pages 25 to 26, it is the Commonwealth's motion for the competency evaluation specifically, and he cites Blaisdell and other cases dealing with the Rule 14 procedures as the basis for that. The court ordered that the Commonwealth do that in a margin, and that should be contrasted to the other motion the Commonwealth filed that day, which was to have the defense state whether they're going to raise a insanity or diminished capacity defense, and that the judge wrote waived, the defendant agrees to do that.
Well, it was actually the at least in the Commonwealth's appendix, the defendant's, Mr. Bourbeau's notice is the same date, June 18th.
Right. So it's clear that when the defendant agrees to it, it's waived because he agrees, but when he doesn't agree to it, the court actually orders it as allowed. Also, as far as whether Dr. Carroll based his, whether he actually had a conversation with Bynum Harris, he states in his testimony, pages, well, it's volume 6, pages 106 to 109, he confirms that his interviews, 4 of them with Bynum Harris, consisted of him asking Bynum Harris questions and Bynum Harris answering them, and that was the basis of his decision, so it certainly was testimonial.
Now, was counsel present for the competency?
It looked as if once Dr. Carroll notes that there in the room are 2 attorneys of his. I don't see anywhere where it's written that the attorney is actually sitting there listening to this going on or that it was an issue. There was certainly no motion to be present during the competency evaluation.
No, counsel,
Oh, time is up.
your
Okay.
time is up.
That was a fast 2 minutes.
Yes.
Thank you.
All right.
All right.